The federal courthouse in Miami stood imposing against the morning sky, its marble columns gleaming in the sunlight. Inside, the ceremonial courtroom was filled to capacity with attorneys, law students, and judicial officials gathered for the National Conference on Judicial Modernization. Judge Aileen Cannon, known for her deliberate judicial temperament, rose from her seat at the panel discussion on court efficiency. The room quieted as she approached the microphone, her expression thoughtful and measured. "Representative Crockett," Judge Cannon began, her voice resonating through the hushed chamber. "Having reviewed your comprehensive judicial modernization bill and observed your leadership on the House Judiciary Committee, I must say this. Your approach represents the most balanced, thoughtful framework for modernizing our federal court system that I've seen in my judicial career. Today, I'm officially endorsing this initiative." The courtroom fell utterly silent for a moment as the significance of this statement registered. Judge Cannon, appointed by a Republican president, was publicly supporting legislation authored by Representative Crockett, a progressive Democrat. Then, starting from the back of the room, applause began, hesitant at first, then building into thunderous approval that transcended political divides and united the legal professionals in shared recognition of excellence. What happened in the next few minutes wasn't just an unexpected judicial endorsement. It was a moment that would reshape how America approached judicial reform. If you value moments when professional excellence transcends political divisions, please like this video and subscribe to our channel for more content that celebrates bridges being built across America's institutions. To understand the significance of Judge Cannon's endorsement of Representative Crockett's Judicial Modernization Initiative, we must examine the backgrounds of these two accomplished legal minds and the challenging landscape they navigated. Judge Aileen Cannon had built a reputation for methodical legal reasoning throughout her career. After graduating with honors from Columbia Law School, she served as an assistant United States attorney in Florida, where she handled a diverse range of cases with meticulous attention to detail. Her judicial philosophy emphasized strict textual interpretation and judicial restraint. "Judge Cannon approaches every case with extraordinary care," noted James Richardson, a court observer who had followed her career. "She's known for thoroughly examining all perspectives before rendering judgment, regardless of political implications." Appointed to the federal bench in 2020, Cannon quickly established herself as an independent thinker who defied easy categorization. While some expected her to adhere strictly to conservative jurisprudence, she surprised observers by occasionally breaking with expected positions when she believed legal principles required it. Representative Jasmine Crockett had followed a markedly different path to prominence. After excelling at the University of Houston Law Center, she built her reputation as a civil rights attorney, often representing clients from marginalized communities. Her courtroom style was characterized by passionate advocacy combined with meticulous legal preparation. After entering Congress, Crockett surprised many by focusing intensely on the nuts and bolts of judicial administration rather than purely ideological battles. She immersed herself in the technical details of court operations, case management systems, and access to justice initiatives that rarely made headlines. "What distinguished Representative Crockett from many of her colleagues," explained Dr. Miranda Johnson, professor of legal institutions at Georgetown, "was her willingness to tackle the unglamorous but essential work of making our courts function more effectively for all Americans." The American judicial system they both served was facing unprecedented challenges. Court dockets were backlogged by years in many jurisdictions. Technological systems varied wildly across districts, creating inefficiencies and access barriers. The costs of litigation had risen so dramatically that middle-class Americans increasingly found themselves unable to afford legal representation. Against this backdrop, Crockett had spent 18 months developing the Judicial Modernization and Access to Justice Act, consulting with experts across the ideological spectrum and visiting courthouses in rural, suburban, and urban settings to understand diverse needs. "What made Crockett's approach unique," explained former federal judge Thomas Reynolds, "was that it wasn't driven by ideology but by a genuine commitment to making our courts work better for everyone." She gathered perspectives from conservative and liberal judges, rural court administrators and urban legal aid attorneys, business leaders and consumer advocates. Have you encountered other examples of leaders who put practical problem-solving above partisan politics? Your perspectives in the comments help us identify more stories of constructive leadership worth sharing. The National Conference on Judicial Modernization had brought together an unusual mix of participants: federal and state judges, court administrators, legal technology experts, and legislators from both parties. The three-day event in Miami was designed to address the growing crisis in America's courts. The morning session featured a panel discussion titled "Balancing Efficiency and Due Process in the Digital Age." The moderator, retired Supreme Court Justice Alicia Martinez, had just opened the floor for questions when Representative Crockett raised her hand. "Representative Crockett," Justice Martinez acknowledged, "you've recently introduced comprehensive legislation on this very topic. Would you share your perspective with us?" As Crockett approached the podium, the atmosphere in the room shifted subtly. Many attendees knew her only through media portrayals that emphasized her progressive credentials rather than her detailed work on judicial administration. "Thank you, Justice Martinez," Crockett began. "I appreciate this opportunity to discuss court modernization not as a partisan issue, but as an access to justice imperative." She activated her presentation, and the screens displayed a detailed flowchart of the current federal case management system with its bottlenecks highlighted in red. "The legislation I've introduced addresses three core challenges," Crockett explained. "First, the technological disparities between court districts that create what we call justice deserts in underserved areas. Second, the procedural inefficiencies that delay resolution for all parties. And third, the cost barriers that effectively deny access to millions of Americans." Judge Cannon, seated on the panel, leaned forward with interest as Crockett began describing specific technological solutions that had been pilot-tested in diverse jurisdictions. "In rural Mississippi," Crockett continued, "we implemented a simplified e-filing system that reduced errors by 78% while cutting staff processing time in half. The same system was then adapted for the Southern District of New York, proving it could scale from a court handling hundreds of cases to one managing thousands." The presentation shifted to show before and after metrics from both jurisdictions, demonstrating similar improvements despite their dramatically different caseloads and demographics. "Representative Crockett," interrupted Judge William Forster, known for his conservative judicial philosophy, "these technological improvements sound promising, but aren't you concerned they might sacrifice deliberation for speed?" It was the kind of challenge that could have derailed the discussion into ideological territory, but Crockett's response surprised many in the room. "That's a crucial concern, Judge Forster," she acknowledged, "which is why Section 204 of the bill explicitly protects judicial discretion to extend timelines when necessary for proper consideration. We consulted with judges across the philosophical spectrum to ensure we weren't sacrificing careful deliberation for efficiency." She displayed the relevant section of the legislation, which included language specifically addressing Foster's concern. His eyebrows raised slightly in acknowledgment. As Crockett continued her presentation, she addressed each potential objection with specific provisions in the legislation, often citing the judges or legal scholars, from diverse ideological backgrounds, who had helped craft those sections. When discussing the bill's approach to pro-se litigants, she highlighted a guided filing system designed with input from both legal aid attorneys and judicial efficiency experts. "This system," she explained, "simultaneously helps unrepresented parties file properly formatted pleadings while also protecting courts from frivolous litigation through built-in educational screens." The audience, particularly the court clerks and administrators, nodded in appreciation of this balanced approach. Judge Cannon, who had remained thoughtfully attentive throughout, finally posed her own question. "Representative Crockett, your technological solutions are impressive, but I'm concerned about implementation costs for smaller districts already operating under budget constraints. How does your legislation address that challenge?" It was a substantive question that went to the heart of practical implementation, exactly the kind of detail that often derailed well-intentioned reforms. Crockett smiled slightly. "Judge Cannon, that concern shaped our entire funding approach." She advanced to a slide showing a tiered implementation schedule. "Rather than a one-size-fits-all mandate, we've designed a phased rollout with additional resources allocated to smaller districts." She displayed a detailed budget breakdown showing how the legislation provided proportionally greater implementation support to resource-constrained courts. "Additionally," Crockett continued, "we've established a technical assistance corps of experienced court administrators who will be deployed to help smaller courts implement these systems without overwhelming their existing staff. Judge Cannon made notes as several other panel members nodded with interest at this practical approach. As the session continued, Crockett methodically addressed questions about security, training, and maintenance, all with specific provisions and data from pilot programs. What became increasingly clear to everyone in the room was that her legislation wasn't a political document, but a carefully crafted solution to real-world problems faced by courts across the country. When the formal session ended, something unusual happened. Instead of the typical quick dispersal to coffee and networking, attendees remained engaged in substantive discussion about the proposals. Judges with dramatically different judicial philosophies were seen comparing notes on how specific provisions might affect their courts. The confrontation many had expected, between progressive ideals and judicial traditionalism, had transformed into a collaborative problem-solving session focused on practical improvements to the justice system. The afternoon session of the conference was scheduled as a working group on implementation challenges. As attendees returned from lunch, there was a noticeable shift in the atmosphere. The morning's presentation had moved the conversation from theoretical to practical, and judges who rarely found common ground were engaged in detailed discussions about court modernization. Judge Cannon arrived early, reviewing her notes from the morning session. When Representative Crockett entered, several attendees approached her with specific questions about how the legislation would affect their jurisdictions. What had begun as a formal presentation was evolving into a collaborative workshop. Justice Martinez called the session to order. Before we break into working groups, Judge Cannon has requested a few minutes to address the conference. A subtle murmur of interest spread through the room. Judge Cannon was known to be deliberate in her public statements, particularly on matters that might have political dimensions. She approached the podium with the measured pace that characterized her courtroom demeanor. The room quieted immediately. "I've served on the federal bench for a relatively brief time," Judge Cannon began, "but long enough to recognize the significant challenges facing our judicial system. Before today, I had reviewed portions of Representative Crockett's legislation with professional interest, but some skepticism about whether it could bridge the practical and philosophical divides within our judicial system." She paused, glancing down at her carefully prepared notes. "Having now examined the complete framework and heard the representative's detailed explanation, I find myself reassessing that position." The attendees, many of them veteran court observers, recognized they were witnessing something unusual, a federal judge publicly reconsidering her position based on substantive evidence. "What distinguishes this legislation," Cannon continued, "is its focus on enhancing judicial effectiveness regardless of judicial philosophy. The provisions on technological standardization maintain appropriate judicial discretion while eliminating needless procedural barriers. The approach to pro se litigants respects both access principles and efficiency requirements." Judge Cannon looked up from her notes, making eye contact with Crockett before addressing the full room. "As a judge appointed by a Republican president, I'm well aware that endorsing legislation authored by a progressive Democratic representative may raise eyebrows. But our obligation as judges transcends partisan considerations." The room grew completely still as attendees sensed they were witnessing a significant moment. "Having studied law and served our justice system for decades, I've developed certain principles about judicial administration. These principles include maintaining appropriate judicial discretion, ensuring due process while promoting efficiency, and making courts accessible without sacrificing rigor." Judge Cannon's voice grew more resolute. "Representative Crockett, having reviewed your comprehensive judicial modernization bill and observed your leadership on the House Judiciary Committee, I must say this: your approach represents the most balanced, thoughtful framework for modernizing our federal court system that I've seen in my judicial career. Today, I'm officially endorsing this initiative." The silence that followed was profound. Everyone present understood the significance of this statement coming from a judge with Cannon's reputation for careful jurisprudence. Then, from the back of the courtroom, someone began to applaud. The applause spread quickly, building into a standing ovation that united the diverse attendees in recognition of this moment of principled leadership that transcended political divisions. Judge Forster, who had posed challenging questions earlier, was among the first to rise. Judges appointed by presidents from both parties stood together, joined by court administrators, attorneys, and legislators in a rare moment of unified purpose. When the applause finally subsided, Judge Cannon spoke again. "I'll be communicating my support to the Judicial Conference of the United States and encouraging my colleagues to evaluate this legislation on its merits rather than its source." She then did something unexpected, inviting Representative Crockett to join her at the podium. "The challenges facing our courts affect all Americans, regardless of political affiliation," Cannon continued. "Finding solutions requires the kind of thoughtful leadership that puts practical improvements above partisan positioning." Crockett, clearly moved by this unexpected endorsement, responded with equal professionalism. "Judge Cannon, your willingness to evaluate this bill solely on its merits exemplifies the judicial integrity that our system depends upon. This legislation reflects input from judicial officers across the philosophical spectrum, including many who share your approach to jurisprudence." What followed was even more remarkable. Judge Cannon proposed restructuring the afternoon's working groups to focus specifically on implementation details of the legislation. Within minutes, the conference had transformed from a theoretical discussion into a practical planning session. Judges with decades of experience were seen clustered around tables with court administrators and technology experts, examining specific provisions of the bill and suggesting refinements based on their diverse experiences. The usual divides, between rural and urban courts, between judges appointed by different presidents, between administrators and judges, seemed temporarily suspended as participants focused on their shared goal of improving the justice system. One veteran court observer was overheard remarking to a colleague, "I've been covering the judiciary for 25 years, and I've never seen anything quite like this." Judges from across the spectrum actually working together on practical solutions. As the working groups continued their discussions, cameras captured Judge Cannon and Representative Crockett moving from table to table, listening carefully to concerns and suggestions, occasionally making notes on potential refinements to the legislation. "This isn't just about political differences being set aside," noted Dr. Elizabeth Chen, a judicial scholar observing the proceedings. "It's about recognizing that complex systems like our courts require diverse perspectives to function effectively. What we're seeing is the kind of collaborative problem-solving that our founders envisioned, but that has become increasingly rare." By the end of the afternoon session, what had begun as a routine conference panel had evolved into something approaching a judicial summit on modernization. The practical refinements suggested during the working groups were being compiled into a comprehensive document to inform potential amendments to the legislation. As Judge Cannon and Representative Crockett concluded the session together, the sustained applause that followed wasn't merely courteous. It was a genuine expression of appreciation for leadership that had reminded everyone present of their shared commitment to justice beyond partisan divisions. In the weeks following the National Conference on Judicial Modernization, the impact of Judge Cannon's endorsement of Representative Crockett's legislation rippled through legal and political circles in ways few could have anticipated. The American Bar Association Journal featured the moment on its cover with the headline, "Bridging the Bench, When Judicial Excellence Transcends Political Divisions." The article detailed how the substantive collaboration between Cannon and Crockett represented a potential model for addressing institutional challenges. What made this moment significant wasn't merely that a Republican-appointed judge endorsed Democratic legislation, wrote legal analyst Michael Sanderson. It was that both Judge Cannon and Representative Crockett approached court modernization as a technical challenge requiring diverse expertise, rather than as a political battleground. Within the federal judiciary, the endorsement sparked renewed discussion about court administration. The Judicial Conference of the United States established a special committee to evaluate the legislation's provisions, with Judge Cannon appointed as co-chair alongside a judge appointed by a Democratic president. "We're seeing something remarkable in the judiciary's response," explained Dr. Rebecca Matthews, who studied federal court administration. "Rather than the usual polarized reaction to congressional initiatives, judges across the philosophical spectrum are engaging with the substance of these reforms." The legislation itself gained unexpected momentum in Congress. Traditional opponents of judiciary-related bills found themselves in the awkward position of opposing measures endorsed by judges they had previously championed. Several key Republican senators, after consulting with judges in their states, announced their support for the core provisions of the bill. Senator James Richardson, a longtime Judiciary Committee member, explained his position. When judges I respect tell me these reforms will help them administer justice more effectively while maintaining appropriate judicial discretion, I listen. This isn't about politics. It's about making our courts work better for all Americans. The bill's progress revealed something significant about American governance that had been obscured by years of partisan conflict. When legislation addressed real institutional needs with technically sound solutions, bipartisan cooperation remained possible. 6 months after the conference, a modified version of the Judicial Modernization and Access to Justice Act passed Congress with substantial bipartisan support. The final legislation incorporated many of the refinements suggested during the conference working groups, making it a genuine product of diverse judicial perspectives. At the bill signing ceremony, both Judge Cannon and Representative Crockett were invited to attend, an unusual honor for a sitting federal judge, but one that recognized her pivotal role in building support for the reforms. President Martin acknowledged their contribution in his remarks. This legislation demonstrates what's possible when public servants focus on solving real problems rather than scoring political points. Judge Cannon and Representative Crockett have shown us that excellence in public service transcends partisan divisions. The implementation phase revealed another unexpected benefit of the collaborative approach. Because judges and court administrators from diverse jurisdictions had contributed to the legislation's development, the resulting systems were more adaptable to different court environments than previous top-down mandates had been. We're seeing remarkable adoption rates across jurisdictions, noted Judicial Administration quarterly in its first-year assessment. Rural courts that typically struggle with federal technology mandates are implementing these systems months ahead of schedule, largely because their specific constraints were considered during the design phase. The human impact became increasingly apparent as the reforms took effect. In the Southern District of Alabama, a simplified filing system allowed a small legal aid office to double the number of domestic violence victims they could assist with protective orders. In the Northern District of California, streamlined procedures reduced the time from filing to first hearing in civil cases by 47%, benefiting plaintiffs and defendants alike. The beauty of these reforms, explained Court Administrator Susan Williams, is that they don't advantage any particular type of litigant or legal philosophy. They simply make the mechanics of justice work more efficiently, allowing judges to focus on substantive legal questions rather than procedural hurdles. Law schools began incorporating the development and passage of the Judicial Modernization Act into their curriculum, not just in courses on court administration, but in classes on legislative process and professional responsibility. The Cannon-Crockett collaboration offers a powerful lesson for future lawyers, explained Professor James Henderson of Yale Law School. It demonstrates how legal professionals can address systemic problems by focusing on shared objectives rather than political divisions. 2 years after the conference, a comprehensive study by the Federal Judicial Center documented the reform's impact. Case processing times had decreased by an average of 34% across jurisdictions, while measures of litigant satisfaction, regardless of case outcomes, had increased significantly. Most importantly, access metrics showed more Americans from middle and lower income brackets successfully navigating the federal court system without attorney representation. At a judicial conference commemorating the 2-year implementation milestone, both Judge Cannon and Representative Crockett were invited to reflect on their unlikely collaboration. "What I've learned through this process," Judge Cannon observed, "is that maintaining judicial independence doesn't mean refusing to engage with legislative reforms. It means evaluating those reforms based on how they affect our ability to administer justice effectively, regardless of their political source." Crockett nodded in agreement. "And from the legislative side, I've learned that effective reform requires genuine engagement with the people who must implement it daily. The expertise of judges and court administrators isn't just helpful, it's essential to creating workable solutions." As they concluded their remarks, Judge Cannon revealed something she had never publicly shared before. "When I first received Representative Crockett's draft legislation, I approached it with professional skepticism, not because of its source, but because most attempts at court reform fail to appreciate the practical complexities of judicial administration. What convinced me was the evident care taken to understand those complexities. The legislation reflected countless hours of listening to diverse judicial perspectives." She continued, looking directly at Crockett. "That approach represents the highest tradition of public service, placing effectiveness above ideology and listening above asserting. It's an approach our founders envisioned, and that we would do well to embrace more broadly. The sustained applause that followed wasn't just for the successful reforms, but for a model of leadership that transcended the partisan divisions that had come to dominate American public life. As the commemoration concluded, a simple plaque was unveiled in the federal courthouse where the original conference had been held. It bore a quote that had come to symbolize the spirit of the reforms. Justice is best served when those who administer it focus not on their differences, but on their shared commitment to equal justice under law. The story of Judge Cannon's support for Representative Crockett's Judicial Modernization initiative offers a powerful reminder that even in divided times, leadership focused on substantive excellence can transcend political boundaries. Their example demonstrated that institutional improvement is possible when skilled professionals prioritize functional solutions over partisan positioning. If you found value in this story of cooperation across differences, please take a moment to like this video and subscribe to our channel. In a media landscape often dominated by conflict, we remain committed to highlighting moments when Americans find ways to work together toward shared goals despite different perspectives. These moments remind us that beneath the partisan narratives that dominate headlines lies a deeper tradition of pragmatic problem-solving that has sustained American institutions through times of division. Our nation's challenges remain complex, and perspectives on solutions will continue to differ significantly. But the Cannon-Crockett collaboration reminds us that addressing these challenges effectively requires not just advocating for particular positions, but the willingness to recognize excellence and practical wisdom wherever they appear.